Hageman for 5 minutes.
Thank you, and thank you for the witnesses being here today. Deputy Director Gerton, before I get into some of the important bills in front of us today, I'd like to follow up with you on our last conversation. You told me in July that by the end of the month, the Fish and Wildlife Service would release its 12-month finding on the Greater Yellowstone ecosystem grizzly bear. And you also stated at that time, or agreed with me at that time, that if we had the number of bears in 1975 that we do today, which is about 1,100 head, they never would have been listed in the first place, meaning that the grizzly bear is in fact fully recovered. But however, not only did the service fail to come through with the release of its 12-month finding at the end of July, you actually delayed any decision until January of 2025. Director Gerton, as I'm sure you are aware, the service is already in violation of the law by a long shot, by a year and a half or more, in fact, in terms of the amount of time under the Endangered Species Act. So as you're sitting here today, the Fish and Wildlife Service is violating the Endangered Species Act with regard to the Greater Yellowstone ecosystem grizzly bear. It is unclear to me what changed in the 2 weeks between the July hearing and the announcement to postpone the 12-month finding to justify such an action. What happened?
Thank you for your question, Congresswoman. When I provided the testimony on July 10th, my goal is always to provide the latest factual update information to members of the committee. The very next day, on July 11th, we received a notice of intent to sue from the state of Montana. And so over the intervening 2 weeks, the decision was made by the Department of the Service that we needed to address all 3 of the pending cases for the DPS.
But the notice of intent to sue was not for the Greater Yellowstone ecosystem.
Agreed, but we have to do an analysis of the DPS in the lower 48.
No, our 12-month review was ahead of that. You have to follow the Endangered Species Act, and you were required to issue a decision within 12 months after receiving Wyoming's petition. Isn't that correct?
That's the statutory requirement, yes, Congresswoman.
And in fact, Montana is not suing over the Greater Yellowstone ecosystem grizzly bear.
A notice of intent for our failure to meet the determination for the DPS in the Northern Continental Divide ecosystem.
So what do we do? Who goes to jail? Who's fined at the Fish and Wildlife Service for violating the law?
Well,
who gets held accountable for this?
So
Do you? Who gets held accountable?
Our stance at this point, Congresswoman, is that we are, and we've published a declaration given to the court that's available on our website. We're linking the 3 of these and planning by January 31st to issue these findings for the Northern Continental Divide, for the Greater
That is not what the
Yellowstone,
recovery plan required.
and for the delisting that was petitioned for the lower 48.
But that is not what the recovery plan required.
A recovery plan is a planning document, it's a blueprint, it's an aspirational document.
But you're agreeing that that is not what the recovery plan required, aren't you?
Yes, ma'am.
I'd like to talk to you very briefly about the BIDA rule. It creates a default position for the National Wildlife Refuge system by prohibiting certain practices unless the refuge managers conduct a full-blown NEPA analysis. Refuge managers would be required to complete an analysis to justify utilizing existing management practices that are necessary to meet statutory responsibilities and to maintain the health of the environment. Deputy Director Gerton, the service states that the intended goal of this rulemaking is to promote management flexibility and empower refuge managers. How does prohibiting important agricultural practices, prohibiting predator control, prohibiting the utilization of genetically modified crops, and prohibiting the utilization of pesticides provide greater flexibility for refuge managers?
Congressman, I guess your question is getting to the default language that's in the proposed rule. That action is prohibited unless we do our homework, we do the science, we show our work. We believe that many of those practices, particularly agriculture, will continue because they are used to mimic a lot of natural functions.
But that's not the default position, is it?
No, I'm not disagreeing with that. I'm saying we are still going to go through this homework and then allow agriculture
How does
to proceed.
requiring a full-blown NEPA analysis for existing practices provide additional flexibility?
Well, the BIDA proposal in and of itself is not requiring a full-blown NEPA analysis. We rely on the existing and underlying analyses that are in place, the same with the cooperative agriculture agreements. We'll address those when they're up next time, 5 years, 6 years, and address them at that time. We'd
Mr.
be glad to
Gurdon?
follow up with your office for some more.
Well, I would like you to follow up with my office, and in fact, I really would have appreciated had you followed up with my office the next day after the hearing, when you assured me that we would have a 12-month finding related to the greater Yellowstone ecosystem, and I'm actually very surprised that you failed to notify my office of that when you were going to take a different route, having in fact testified to something different the day before.
Well, I certainly apologize for any confusion. Not to argue with you, I understand your office was contacted later in the month, but we can certainly do a better job. I'm sorry, I can't see you or the gentleman there. We can do a better job reaching out to you future and giving you more fulsome and updates as they come along.
Please do.
We'd be glad to do that.
Thank you.
Yes, ma'am.
Thank you, Congressman Grothman.